Unfortunately, that letter, I think, also was detained by the prisons. We wrote a letter on Friday, last week, expressing further our dilemma. Having received the ruling, I think that day, saying that the hearing was to begin today. We wrote a letter on Friday. I doubt that it is yet before court. The prisons have it. So we have challenges in prison, we have challenges in court. Well, I wanted to address you on the environment that has been caused now by the arrest of Mr. Museveni on Saturday on this case, because it is before you.
Let me first listen to the challenges for hearing today and why the lawyers are not here.
And then I will come back.
I must resolve that.
My Lord, for record, Captain Dennis Oola. I want to be very brief. Most of the things have been said by everyone. But I want to talk specifically concerning myself and possibly why the lawyers are not here. The last time we were here on Hajj,
The reason why the lawyers are not here is
when we were here on Hajj, you promised to give a ruling of that day by 8. As I talked of now, I've never received any. A ruling of that day. And even coming to court, I was just told today by 9. You promised to give a ruling on that day. I did. Not at all. And for today's hearing, they did not tell me that I was coming for hearing. They just informed me that I'm coming to court today at 9. I had no idea that court would be there today. And therefore I have never contacted my lawyers. And I'm not sure whether they are also aware that court was supposed to be there today. So, to tell court why they are not here, I'm really not in the position. Because personally, I never knew there was court session today. It's made clear that next time service of such should really be done to all, so that we can prepare. But in addition, there is still also need for me to have access to the facilities. And so that I can get to understand what is in the disclosure. Thereafter, we get ready for hearing. Thank you.
Yes, we might get to it.
But you are given us
We still want to say,
yes.
I don't look ahead. So
Yes,
we
It's clearly the reason
that's the minimum.
again all these touches on the fair here. You know?
I'm giving you another chance to address court on the river representation, which is affecting today's hearing. So that I'm able to respond.
I have addressed court regarding the legal representation.
Yes.
I want to address court regarding a statement of Mr. Muslim which touches on the fair hearing of this case.
That one, today we are not handling that. Today it is here. So let me get the challenges you have for hearing.
Precisely, this is a challenge for our hearing. Because statements that were made touch on this hearing.
That one I have captured that.
Yes, so let me tell you what they are.
No, you can't go to that address. So I need to know the challenge you have told the court.
That is a challenge. The address is a challenge. Because it's an address to the whole country, it affects the nature of this case, it influences the assessors, it influences everybody in this case, including yourself.
So I am saying that you can address me, if you have already addressed me on the challenges of legal representation.
Yes, and this is a challenge on this fair hearing before you.
I have captured that.
So I can go ahead and address you on it.
You have addressed both of the challenges of legal representation today.
Yes, I'm not addressing you further on the challenge of legal representation. I'm
Today we
addressing
are here
you.
for hearing.
I'm addressing you on what Mr. Museveni said on Saturday the 4th, which has
The
strong.
issue before court to resolve is legal representation, the challenge.
So when do I raise this?
You said that there is an application. You want me to listen to the application without court? You said there is a pending application.
Yes.
You want Hajj to now?
The pending application is on the representation.
So, and that's what we are handling now. So what you are saying, we cannot go to the merit that is. But today let us handle why we cannot go.
I don't know whether you have received the letter we wrote on Friday to this court, because it also contained some of these matters.
We also wrote a letter.
Yes, which is with the prisoners authority. And we are here, maybe they can confirm whether we have brought it to have it.
About the same.
Yes, about these issues. We want to put you on record.
So that one, so that I allow the respond. July, so later, was it what did you Friday? About the letter?
My Lord, all articles written to go through the verification process before they are forwarded. All articles written by the accused, they undergo a verification process.
Is this forwarded or still undergoing? That's what
I beg to confirm the status of the said letter.
So I'm not sure if it's correct.
Yes, my Lord.
Okay, let the state reply because this was.
I forgot to mention, excuse me, I forgot to mention that we have also filed a notice to appeal your ruling. Appeal the ruling in our application of 7. And we again need a record of proceedings, proceed with that appeal.
So you are not so appealing which ruling?
In the ruling of application number 227. That is the human rights enforcement application.
Okay. It's noted. So state.
My Lord, for record, my Lord, Richard Billy from Oola, Chief Secretary, for prosecution. My Lord, in response to the issue of representation, the accused persons, maybe to start with A1 and A2, I think that's why it is more contentious. Are represented by more than 35 lawyers. A1 and A2 are represented by more than 35 advocates. And they have been on record since this matter, my Lord, moved from the Chief Magistrate's Court, Nakawa, to this Honorable Court. the right of the accused persons, legal representation, and more so by advocates of their choice. As envisaged under Article 28 of the Constitution, and Section 56 of the Trial on Indictments Act. Because it constitutes part of the fair hearing. My Lord, since the last sitting, A1 and A2 have been unrepresented. Unrepresented. And in his submission, that is our senior citizen and great statesman, Dr. Kizza Besigye, one, he submitted that the lawyers were not in court because Senior Counsel Martha Karua, last time, even last time, yes, my Lord. Yes, I'm bringing my thing properly, my Lord. I'm reverting it, my Lord, because without that I can't make my point. He argued that they were not in court simply because Martha Karua and yes, my Lord.
I didn't hear him talk about Massa and others. We first heard court to address the concerns, their concerns today. Why this?
My Lord, it's going to help you in this matter very well.
No,
because I'm not going to do very much. Okay, my Lord. My Lord, we have never received any notice we have never received any notice of withdrawal of instructions from any of these lawyers. And actually, even the accused persons, that is A1 and A2, have equally not informed this court that he withdrew instructions from all the lawyers who are representing him since this matter started. So the assumption is that the instructions are still active. So therefore, when the accused person appears in court unrepresented the way he did last time, it's becoming habitual. And my Lord, it is either unexpressed or implied notice to this court that they have waived their right to legal representation of lawyers of their choice. And my Lord, this act is frustrating the hearing of this matter, because the principle fair hearing, or the issue concerning hearing, is not only about the accused persons. It is about the accused persons and other parties that are involved, including the public. My Lord, ever since we did our last disclosure, which I think a month or plus ago, prosecution has been ready to have this matter heard. But we have been arm-twisted, always. And there has been a picture that has been painted to look as if prosecution is the one frustrating the trial or the hearing of this matter. We want to make it categorically clear that we have been ready to have the accused persons tried. Today we have witnesses and we came ready to have the matter heard. My Lord, this in effect constitutes an abuse of the legal process. But my Lord, if the accused persons are abusing the process, this court, my Lord, has tools at its disposal under Section 17 of the Judicature Act to make a finding, my Lord, among others, that the accused persons have waived the right to legal representation of their choice.
You
My Lord, section 17. My Lord, section 17.2. With regard to, says, with regard to its own procedures and those of the magistrates' courts, the High Court shall exercise its inherent powers. A. To prevent abuse of process of the court by curtailing delays in trials My Lord? Okay, most obliged, my Lord. So, my Lord, I will submit that this court can make a ruling, a finding, based on that provision, that the accused persons have given up. They have waived that right to legal representation of their choice. The assumption, my Lord, here is that under those circumstances, it becomes a voluntary waiver where most obliged, my Lord. And my Lord, the court in doing so, it can direct the matter to proceed for hearing. And in alternative, court can appoint lawyers on state brief to represent the accused person. And my Lord, it is our prayer that court makes a ruling to ensure that we have the matter tried. We are ready. Because if it doesn't, it's going to create anxiety in the mind of our witnesses. And some of them may end up not testifying. My Lord, as prosecutors or DPP, we are not party to application number 248 of 2026. We are not privy to it, and we are not aware of its contents. And my Lord, we are also equally not aware of the effects of the speech of the President in regard to this matter. My Lord, this court is independent and as per the Constitution, and this matter will be tried best on the facts, evidence and the law.
He's saying he didn't address that matter.
Most obliged, my Lord. Most obliged, my Lord. Most obliged, my Lord. But he hinted about it, my Lord.
Yeah, but I said it is not here, so it
Most obliged. My Lord, we so submit.
Yes,
an opportunity to respond in the brainer of what.
Yes, very briefly, Mr. Judge. The application for it was filed last month. It was raised to the attention of this court on the 1st, on the 30th of June, when we came here to this court. This is also a human rights enforcement application. That we expected would be dealt with as a priority. If it had been dealt with, we would not have been in the dilemma we were on the 3rd. We would have resolved the issue of representation. It was not attended to in the hearing of 30th. It was not attended to in the hearing of the 3rd, in spite of raising it in both appearances. The circumstances that propelled that application were not of our own making. They were the making of the state. Which kidnapped Councillor Yasin Kwango and tortured him. And which arrested and deported Councillor Martha Karu. These were the actions of the state. Illegal actions of the state. If they hadn't been there, there would be no application 248. We would have proceeded normally. The details and the evidence in that application can only be dealt with by hearing the application. And if it's business, dismissing it. not notifying prosecution regarding the lack of instructions, that would be a matter for the lawyers to deal with. It cannot be visited on us. But suffice to say that both on the 1st of July and on the 3rd of July, in this open court, we did on the 30th of June, and on the 3rd of July. In this open court, we did put on record the situation of our representation. In their presence.
So, Doctor, this challenge, how long, according to you, how long can we wait on this river?
If 248 can be had tomorrow and resolved, then the following day we would have a way forward. It hasn't been had since we filed it last month and talked about it in these subsequent appearances. Again, not for emphasis, since it seems Chief State Attorney Bengongoka didn't get it. The disclosures were made to our lawyers. For us to receive them, we need the facilities through the prisons authorities for the lawyers to now make us access them. So, whereas trial, and indeed they said they had a witness here on the 11th, they had a witness in court. But on the 3rd of July, they themselves read a letter that was now, for the first time, allowing access to facilities, which was written by the prisons authorities on the 29th of June. So we are supposed to hear evidence on the 11th, long before prisons conceded to allow facilities to access the disclosures. By the 2nd of July, when that letter came to our notice, and I'm short their notice, the crisis of the lawyers had already emerged. So we have no way of accessing them since July the 2nd, when that letter was written. until the resolution of the legal representation which we are seeking. Regarding what he describes as abuse of process, then I think there must be completely different understanding of the judicial system, the legal and the judicial system we are following. Mr. Bilivumuka must be following the indigenous communities judicial system, while we are following the colonial or neo-colonial judicial system, whereas Mr. Museveni said includes the judges who are actors with wigs. Mr. Judge, the absence of our lawyers was occasioned by the state itself, not by ourselves. And it is the state that has progressively abused the process. It was the state which took us to defunct military court-martial, military tribunal, which had long been declared unconstitutional. The state, the guarantor of the Constitution, nonetheless took us there and charged us in an unconstitutional court, where we spent months. This court ordered for disclosures last year in December to be concluded by January. In a matter where all investigations were complete in May of last year, yet from December, disclosures were completed in June. Our lawyers begged for sanctions against the state. Every appearance, we wanted the court to sanction the state for not following court orders. Which is the same state saying we are the ones abusing the process. Therefore, constitutional rights must be stripped. this court to hear our application to resolve the issue of our lawyers. And once resolved, allow us to access, allow us time to access disclosures and also to give us the record of proceedings. And we shall be ready to face their witnesses. As I ask for, Mr. Judge. Maybe what I forgot, you also talked about other parties which are inconvenienced by delays, saying we are looking at our own situation, not the situation of the other parties. The party, and this is a matter which you also touched on in your ruling on the human rights enforcement application. That those who apply for human rights enforcement seek to erase the rights of the victims. Our trial is of the nature that, because we are accused of treason, actions against the state. So they aggrieve the parties, the state. And it is the aggrieved party violating human rights in this case. Coming with gripping hands to seek justice. So, I wish to reiterate that our applications cannot be an abuse of a process, cannot injure the other party, because it is the other party that is injuring us. So,
This is the ruling of this honorable court. I have very carefully listened to the concerns from the chosen persons and the prosecution. The concerns and the reply from the prosecution, I will quote record, I will not reproduce it. And for the interest of time, I will give a summary of my ruling, and I will avail to you a detailed one later. But briefly, the issue before this honorable court is the issue of equal representation. today, the matter is coming for hearing. The prosecution told the court that they had witnesses around the court. And the prosecution said that they were ready to proceed. However, the accused persons, specifically A1, raised some concerns. Briefly, they are the concerns that affect the legal representation. To be specific, the concerns he raised is that, one, that there is a pending application number 248 of 2026, which is still pending before this honorable court, and it is related to the issues of legal representation. According to the accused persons, that is A1 and A2, they told the court that this application should be disposed of first. I will come back to that. They also raised the issue, the accused persons, of the disclosure. The accused person said that the disclosure was made to their lawyers, who have since got the challenge. And for them, they have not received the disclosure. I will also come back at it. The accused persons also informed the court that they want to be availed with the record of proceedings in this case and the applications, which I will also come back to. Another issue of concern was that the facilities in prison, which prison wrote this honorable court as of the 29th June, that the same be availed to the truth and their team. Another concern is by S3, who raised the issue that he was not given a copy of the ruling in his bail application. Briefly, I will now proceed to make the following remarks and findings on those summaries of the concerns raised by the accused persons. One, I am very well aware and alive with Article 28 of the 1995 Constitution. Briefly, Article 28 provides for the right to a fair hearing. I will go ahead to Article 28.1. Article 28.1 provides that in the determination of civil rights and obligations for any criminal charge, the person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. I have also considered Article 28(3)(d) of the 1995 Constitution. It provides that is 3D, that every person who is charged with a criminal offense shall be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. Indeed, from the time we started this case, the accused persons were permitted the lawyer to the services of the lawyers of their own choice. Not until 30th June and specifically 3rd July, when the lawyers of their own choice that had been representing them were not present in court. I will now go to Article 28, 3E. Article 28, 3E of the 1995 Constitution provides that, I quote, in the case of any offense which carries sentence of death or imprisonment for life, the accused is entitled to a legal representation at the expense of the state. In this instant case, and specifically the concerns raised by the accused persons, I will address all their concerns one by one for the interest of justice. Concern one, that miscellaneous supplication number 248 of 2026, which is allegedly to be pending before this honorable court, or specifically before me. Cases normally allocated to the judges. Judges don't allocate cases to themselves. I want to make it clear that from my knowledge, miscellaneous application number 248 of 2026, which the accused persons are talking about, has never been allocated to me as a judge. It's not before me. But the registrar can find out from the registrar who allocates cases. But the said application has never been allocated to me, and the same application cannot use it or debate it to hold this trial, because it is not until that the same application is allocated to me that I would know the content. But at this stage, I don't know the content of that application, which has never been allocated to me, that I can form a mind to hold this trial in session number 335 of 2025. I will go to the issue of disclosure. The accused persons have told the court that the disclosure was made to their lawyers. True, from court record, the final and full disclosure was made on the 1st of June 2026. And I will take what the accused persons have told me, that they have never received such a disclosure since the disclosure was received by the lawyers who have since got challenges. I now order and direct the prosecution that for the interest of justice, at the end of this sitting, I'm ordering you make avail of the disclosure to the accused persons before court here. From their own, since the other one, according to them, was made to their lawyers. So at the end of the sitting, prisons kindly hold on around the prosecution to avail all the evidence they intend to use, in this case, avail it to the accused persons themselves. In case there is any challenge of the prosecution to do that, serve all the evidence we got rely on today, of which I believe, and I told court that they were already with witnesses, I guess they had that evidence they intended to use, so avail it to the accused persons themselves. On the issue of proceedings, in this case, and other applications, I'm directing the Registrar of Criminal Division to avail the copies. In any case, the proceedings are by transcribing. So the IT should help the registrar to have these proceedings in this main case and applications, so that the registrar can certify them and serve the chosen persons. This one can be done by tomorrow, which is 14th. And let the registrar, the IT, together with Lutale prison, they should get these proceedings and arrange them to the chosen persons. I will now proceed with the facilities in Lutale. As the chosen persons and specifically A1, it is on record that at least by 29th June, the Lutale people wrote this honorable report, and the letter is in record, that they had granted almost several facilities to the chosen persons and their legal team, and directing Lutale to adhere in the same. I want also to go ahead and comment on the ruling for S3, that it was unfortunate that you have not received the copy of the ruling. Yet this court directed the registrar and the Lutale people to avail you with this ruling. I will now again direct the registrar and Lutale people, even Lutale people before you go, make sure that you find out where it is, whether the registrar or the Lutale, so that this is able to get his copy. For the interest of justice, and specifically to address the issue of legal representation, the chosen persons have been represented by lawyers of their choice as per Article 28, 3D, from the time we started this case, at the time of the pre-taking. However, it is my considered view that the chosen persons were permitted to have lawyers of their choice from day one. But since this court keeps getting concerns from the chosen persons that they have challenges with their legal representation, specifically lawyers of their own choice, this honorable court will move to look at the relevant laws. In case such a challenge keeps on, because my view is that there must be a solution for the trial to commence, and I am aware and alive of the right to the fair hearing. And my view, this case has suffered several delays, and indeed the chosen persons have said they have been on remand for some time. So this honorable court has decided to invoke Article 28(3)(e), which provides that the chosen persons are entitled to legal representation at the expense of the state in the cases of any offense which carries a sentence of death or imprisonment, life imprisonment. In the view of the above, the registrar, criminal division, is directed to avail